李慧瓊議員。
Ms. Starley. Mr. Deputy, the bill the bill resumed second reading in December. But to block the bill, members played with the rules and caused several abortive meetings. They are going after political ends. They waste the time of the council, cause a congestion in this council. They hijack the rules of procedures. According to newspaper report, Mr. Wong Kok-heng said that those who do filibustering are the chairman of the council. They are calling the shots. We are now in 2016. After much time, we now resume second reading. Many members still say that there shouldn't be resumption second reading. They keep asking for quorum calls. They ask the administration to withdraw the bill and conduct the consultation again. After so many years, if today is not the time for resumption the second reading, then when? The next term or another 10 years? And how many 10 years or decades does society have? Now, we should uphold our dignity of the council. Yes, the popularity rating of the council is low. People don't like the inability of the council from the ability to pass projects, PWP, public works projects, to passing legislation. Now people say that the situation is worse. In the past, there were discussions that was indecision. Apart from indecision, now much time is spent on playing with the rules. As for this bill is a stark example, adjournment motion, quorum call, even every meeting of this council is spent on playing with the rules. This confusion has caused concerns among the public. In this solemn chamber, where we should amend the law, pass laws, put questions to the administration, and also pass government budget, it has become a chamber for just doing head counts. People are angry. Now let me go back to why the reasons for supporting second reading resumption of the bill. If this bill is passed into law, then it will help go a long way to promote Hong Kong as the hub of creativity. Some people say that it is the Article 23 of the Internet, and the government will clamp down on freedom of expression. That's exaggeration, that's scaremongering, that's far from the facts. Mr. Deputy, a sound copyright system is very important to economic development, and in particular, the intellectual property with communications rights. The authors can communicate their products through all kinds of means, including electronic means. With the popularization of tablets and mobile phones, Mr. Chen Chi-chen, a quorum call, please.
請同事坐低。
Would members please take your seats? Ms. Starrilli, Mr. President, with the rapid development of the Internet and also the development or popularization of mobile phones, direct sales can be conducted more directly, and the change and transfer of copyright products can be made speedily, and there are new forms of infringement. With infringing streamlining, the copyright industry is facing tough challenges. Mr. Ma Fengkuo, in the second reading resumption, said that in the past 10 years or so, the development of creative industry and their incomes declined. Local gramophone industry declined from $1.1 billion to $300 million, and the development of the receipt of comic industry declined to just $100 million, and number of books published declined to less than 1,000, and box office income for films declined to just $350 million, and the number of films shown declined to just 51 films in 2014. There are many reasons attributable to such a fall, but if you just look at the income of the authors and also the producers, then it is far from the fact that the copyright law is inclined towards the interests of the copyright owners. If what they say is true, then many copyright owners should have made a lot of money. They would have stay away from asking for a change to the copyright law. And some pan-democrats also said that the administration was stubborn and refused to accept contrary views. Let us look at the history of this bill. The legislative work started in 2006. There were 3 rounds of consultation, including the consultation in the digital environment. In 2008, there was a legislative proposal, and then in 2013, there was consultation on parody. And since 2013, the administration, the industry, and the netizens had more than 20 meetings to discuss the content of the bill. The Bills Committee straddled over 2 terms, and we had more than 30 meetings to discuss the proposals. So the administration has done its part in consulting the stakeholders. If you put the blame on the administration for the present stalemate, that is irresponsible. People don't understand the legislative process and timetable. Netizens have different views. We understand that. But we are councillors, we are legislators. When they want to put their views into the bill, they should be more positive and responsible during the consultation period. During the Bills Committee, at the early stage of the Bills Committee, they should raise the issues and cause wider public discussion. That will be a better way to get the support of different stakeholders. Concerning the amendments, which will be discussed later, the DAB has tried to understand the position of the copyright owners to see if we can address the stalemate. Now, they are rather firm. They prefer not to have the bill if the amendments are passed. Each bill, each piece of legislation is a matter of balance. The copyright owners have their demands, and netizens have their demands. the copyright owners have put forward a lot of demands which should be included, such as the advanced copyright measures, such as extending the copyright period, judicial interception, judicial blocking of the infringing websites. These issues have not been discussed. They are asked to swallow it. You can understand their reaction. If you are a responsible councillor, if you are a responsible legislator, then you have to start at the early consultation period to get the experts into discussing these issues, and that will be helpful to get the legislation past this council instead of causing trouble at a very late stage and then put the blame on other people. It's clear that with regard to the copyright amendment bill, the copyright owners say that they accept the bill very reluctantly, even with tears in their eyes. They have already accepted a lot of the compromises. Now, they are against any of the CSAs moved by the Pan-Democrats. They prefer an all-or-nothing outcome, just like the opposition. This attitude is not favorable to the progress of society and also this council. Because of this, different stakeholders have different views, and there are gaps apart. There is a wide gap. Under the present situation, it will be very difficult to get a compromise within a short period of time. We believe that the administration has given the undertaking after the passing of the bill. There will be a new round of consultation, and then the consultation will deal with the outstanding issues, and we find that is appropriate. Mr. Deputy, the DAB is reviewed that any amendment is a balancing act, and the bill should not be biased towards any side. Now, there is introduction of communication rights, and there are also exclusions and exemptions protecting netizens. There is a certain balance. As for the introduction of communications rights, the copyright owners will have their rights protected in the electronic environment. It will be effective in combating piracy. And there is also, for the netizens' protection in terms of parody, satire, caricature, and pastiche, and also commenting on current events, so on and so forth. The causes of being prosecuted will be reduced, and there are clearer provisions to deal with uncertainties. Since the bill has been been discussed within the community and within this council, the bill should first be passed because such consensus is hard to come by. The DAB hopes that this council and the community will support the passing of the bill, and then the administration will then honor its promise and conduct a further round of consultation to deal with outstanding items. Mr. Deputy, let me also respond to some of the views of members. They say that the most worrying part is the introduction of communication rights, or communications right. Communications right is not unique to Hong Kong. The WIPO treaty has already included that, and that is also in line with development of other countries such as Australia, New Zealand, Canada, Singapore, US. They have introduced UK. They have introduced communications rights. Now, if the introduction of such rights will lead to suppression of press freedom, that's far from the fact, and that is also far from the international trend. Some oppose the bill because they say that the bill, when passed into law, will cast a long shadow over the behavior of netizens, and their daily lives will be affected. The administration has to do more publicity and explanation. You should set up a hotline and have dedicated personnel to talk to netizens and stakeholders. You can issue more FAQs and explanations so that they can understand the real content of the bill. As for Ms. Tam's view, the chair of the Bar Association said that the introduction of certain provisions which ban certain behavior which were lawful in the past, that was a big mistake. In fact, the risk of being caught by the law inadvertently is very low. We are legislators. We believe that the government should explain more fully the content of the bill, let the public understand the bill, so that there will be no new content which make people more easily caught by the bill. Thank you. Mr. Wong Yuk-man。
主席，喺我開始二讀發言之前，本席必須就議事規則第83A 條作出呢個利益嘅披露。根據版權條例，本席係版權擁有人，除咗若干個人著作之外，根據版權條例第2、第4條，該等著作構成文學作品，亦有製作聲音、影像紀錄而持有呢啲版權作品嘅版權。本席持有嘅有限公司負責編輯同埋出版上述著作，因此亦都擁有已發表版本的排印編排的版權。其中較近期嘅係比橡皮圖章更不堪香港立法機關崩壞實錄一書。透過有限公司持有網台 My Radio 喺網絡上廣播嘅節目，根據版權條例第8條，係屬於能夠被在香港或其他地方的公眾人士合法地接收的聲音或影像及聲音或表述聲音或影像及聲音的東西。本席因此持有該等聲音或影像及聲音或表述聲音或影像及聲音的東西的版權。主席或者會嫌我頭先所提述嘅又長又拗口、結屈拗牙，係嘛？當中仲有3個或字同埋2個及字，嗱呢啲就係版權條例草案值得修訂嘅地方。本席言語提出嘅修訂案作出改善，但係遭到大會主席曾鈺成不予批准啊！網台節目咧，亦都係藉着光纖寬頻傳送。因此，同時屬於版權條例第9條規定嘅有線傳播節目，全有版權。My Radio 設有網頁，符合條例草案建議安全港制度下嘅服務平台嘅定義。本席喺呢個制度下嘅服務提供者 （service provider）， 我亦都係內容提供者。本席當然亦都係網民啦，我經常上載一啲資料到其他嘅服務平台，例如 Facebook 或者 YouTube， 亦都曾經喺呢啲服務平台收取呢個財務利益。申報完畢，我開始就條例草案二讀發言。請主席開始重新計時，唔該。重新計時啊！我頭先嗰個係申報利益，係唔可以擺喺我發言嗰個二讀發言嘅時間裏邊嘅。
主席要求點算法定人數。
秘書，
佢頭先冇話明我而家申報利益有，一開始就有講。係咯，咁但係主席唔答佢喎。咁因為主席唔識㗎嘛，主席唔知道到底係咪應該咁啊？李慧瓊啊、林美 嗰5分鐘啊，得31人喺入邊啊，佢哋都唔叮，咁死蠢。
黃毓民議員請繼續。
Mr. Wong Yuk-man, please continue. President, Article 6 of the Basic Law. President, I was only declaring interest just now. Mr. Wong Yuk-man. In accordance with Article 36 and RT58 of the ROP, members can only speak 15 minutes here, including declaration of interest, so I cannot have the time deducted. Please continue. Under Article 6 of the Basic Law, private ownership of property should be protected. Copyright as a form of property should be protected under the law. However, the law also ensures freedom of expression, creation, and free flow of information. These informations are also protected by the Basic Law. Without a free public space, you cannot create works that are worthy of protection. We've never heard of infringement activities in the North Korea who would be interested to infringe upon the rights of model operas. Well, in places without freedom, what we hear is not infringement, but leaking of state secrets, and people can be incriminated for their words. So please don't assume that protecting copyrights are in contradiction with protection of freedom of speech, creation, and free flow of information. In fact, the three are complementary. The protection of freedom of speech and creation and free flow of information is the basis for the protection of copyright. And that's why many copyright creators have openly opposed this bill. In examining this bill and also its amendments, I must put protection of freedom of expression, creation, and free flow of information as primary consideration. The Copyright Ordinance was first enacted in 1997 and amended in 2000, 2003, and 2007, respectively. The last term of government presented the Copyright Amendment Bill 2011, but because in 2012, 689 wanted to bulldoze the proposal of 3 directors of bureau and 2 under directors of bureau and 14 bureaus, and the bill became collateral damage of filibustering, so it did not complete its second reading. When considering this, I have pointed out many grammatical mistakes in the English text. Clause 81, or otherwise concerned with the advancement of religion, education, or social welfare, it was missing. It was completely lost in the Chinese rendition. And for the character 重复 in clause 10 and 73, there was again an error, and you can see it, President. And these were still in the amendment bills, so ridiculous. There were mistakes, and yet they are kept in the copyright ordinance because the amendments are not allowed. The Secretary of Justice who presented the bill and is responsible for reviewing our statutes is indeed derelict in its duties, and LegCo has not done its part in proper examination of bills. And Chairman, you are President, you were party to the Bills Committee before you became Chairman, so you are to be blamed, perhaps. And the government has introduced some amendments in the bill, but are they enough? I don't know. Back then, people called the 2011 bill Internet Article 23, and now they still call it this name. So these improvements are not sufficient. Some organizations and members of the public have opposed the bill, and even Wok Kok Kin of FTU have openly called upon the government to withdraw the bill for further public consultation. I think the government should reflect on its own performance. Is the bill sufficient in addressing public concerns? In particular, there are concerns about secondary creation and individually derivative works, and also the possible of criminal sanctions. Is this the right time to pass the bill. It's not just the netizens, even scholars and literary creators have expressed their concern, and the government has rejected to adopt the Canadian model. And some scholars of the view that the framework under the bill is already dated, and many jurisdictions are trying to reform the whole regime. The public are less trustful of the government. They fear that their freedoms are being curtailed. And so it's not wise for the government to pass the bill at this moment. The Director of Intellectual Property have adopted a high-profile approach in explaining the bill on TV, and there are many pictorial illustrations and digests made by the government. In fact, they should have been done long ago, but they were only presented at the 11th hour. And many of the arguments presented by government are self-contradicting and also very far-fetched and flimsy. And some of the media accused the members of supporting or opposing the bill blindly, and there is some truth in such remarks. And online broadcasting of game playing is a challenge to members who are now out of touch with this cyber era. And 689 sang the song I Like You, and the footage was uploaded to the Facebook, and he infringed copyright first and made amends later. At question time yesterday, we heard by surprise that the copyright royalty, or part of the royalty, was as high as $600. And if a netizen is to pay the full royalties, and if a few songs were sung, what will be that the royalty fees could be exorbitant. Many legislators and sectors are very ignorant of the bill, and he brought frontline of the will that we should not blindly support the bill and we should shelve the second reading. I do agree with such proposals. If we pass the bill without a full understanding, then this will be very irresponsible. More waste, more haste. We should buy time for further public consultation and discussions. We should delay the second reading of the bill. And perhaps the administration can dispel some of the misunderstanding of the bill. The adjournment motion was vetoed, but we're still in a stalemate. We're only 3 sittings away from the announcement of the budget. Should the director or the secretary act wisely and consider whether there will be enough time for completing the scrutiny of the bill? In order not to be in the way of the budget, I think the government should do something at the sitting on the 3rd of February. This is political reality. Secretary, you have to face up to it. Depending on our progress, there should be either adjournment or suspension of the consideration of the bill, or you may want to follow what Stephen Lam, the previous CS4A, did when he dealt with reorganization of the government. He invoked ROP 91 for suspension of rules so that the budget could jump the queue, or the bill should be withdrawn altogether. According to our last experience, it took at least 3 days for an adjournment motion to be debated. So I urge the administration to seriously consider my proposal, and that is to withdraw the bill. The political reality is the pro-democrats that are not willing to join this filibustering. Well, when there is a call for quorum, they are not here, so there is a high chance that another sitting will be aborted. And I've also made some observations of the work of the 2 bills committees. May I share with you? For the bills committee set up to consider the 2011 bill, there were only 9 members, including some members whose attendance rate was always on the low side. And you can imagine how many members in the bills committee was serious in examining the bill, and the LP, BPA, and FTU and the APDL had no representatives in the 2011 Bills Committee. And for People's Power, which I still belonged back then, we did not join the Bills Committee, but we proposed more than 1,000 CSA. Now, in the committee, there are 4 pro-democrats, including Emily Lau, Sid Ho, Audrey Yu, and Ronnie Tong. Audrey Yu is no longer legislator. The other 3 members are also members of the 2014 BC. Starting from the 5th of July 2011 to the 27th of May 2012, in those 8.5 months, there were only 11 meetings, and there was the summer recess between the 23rd of July and the 11th of October, and there was the Christmas and New Year vacations, so there were only 4 to 5 months to examine the bill. Now, for the 2014 BC, the number of members increased to 25, and there were 24 meetings. Mr. Ronnie Tong resigned on the 30th of September 2015, and he only attended 6 of the 24 meetings. And Ms. Emily Lau left the BC early on the 5th of May, and Gary Fan, one of the members who were very enthusiastic in this filibustering, left the BC early on the 28th of July. And in the very last meeting of the BC, I propose that the meeting be adjourned for another discussion. However, there were only 4 members present, including the chairman, Kam-lam, and there was a tie, so my proposal was vetoed. The meeting was hastily brought to a close. There was no thorough discussion on CSAs, which had the consensus of members, and they were suddenly withdrawn by the administration. Sid Ho and Sin Chung Kai were present, but they did not support my motion for an adjournment. As a result, the second reading debate of the bill was indirectly advanced. So I fail to see why all of a sudden Sid Ho moved an adjournment motion, and when the motion was defeated, she asked for committal of the bill under ROP 55(1)(a). Chairman, these facts I've just told you, just to be fair. I can only have 15 minutes in this second reading debate speech. I cannot discuss in details issues of concern to the public, safe harbor and citation and report of current affairs, parody, caricature, satire, and pastiche, and also contract override. When we come to the committee stage, I'm going to comment on these one by one. Now, I'm not allowed to have a debate on your ruling, President, but please search your soul. If these amendments were moved by the administration as well, would you just reject them all the same? With these remarks, I'll post second reading of the bill.
Mr. Kenneth Kwok, I think the quorum should comply with the basic law.
請議員返回席。
Members, please return to your seats.
郭榮鏗議員。
Mr. Kenneth Kwok.
President, the Copyright Amendment Bill placed before us is a controversial one. The bill is controversial not only because of the proposed amendments in place, but copyright law itself has always been a controversial concept. If we wish to understand the debate amongst various stakeholders today and create an appropriate copyright legal framework which suits Hong Kong, which suits the digital era, the 21st century, we must first understand what copyright is. In the speeches which I have heard so far, with perhaps the only exception by my honorable learned friend, Mr. Martin Liu, no one has been able to engage in this kind of debate, which I've heard so far. And this is the debate before us. Copyright is a right created by law that grants the creator an original work exclusive rights for its use and distribution. This bill adds another exclusive right to copyright owners, that is, to communicate the work to the public. The copyright owner has a monopoly over that work. This is an inherent dichotomy in the objective of the copyright law. On the one hand, it aims to protect the rights of those who have created the work. The logic is that they will create more than when the value of their work is being protected. On the other hand, the law must be sufficiently liberal to promote further creation, not to stifle creativity. The way that copyright law deals with this dichotomy is to draw a line to disallow anyone other than the creator to deal with the work in any sense, unless consent from the original owner is obtained. Under the current law, together with the bill, not dealing with the work means much more than simply not dealing with the final product of the work. Let's take Spider-Man, for example. Marvel owns the story. Sony owns the characters. If you and I attempt to create another story similar to Spider-Man, there may be a risk of infringement. Copyright owners own much more than the final products. They also own the concepts, the ideas leading to the final product. The law actually freezes certain ideas into property and prevents others from dealing with it. But the law, with the effect of forbidding others to use certain ideas, is fundamentally in conflict with the process of creation. It is an inherent fallacy to say that creation should only be recognized when one creates from scratch. This is not how art, culture, or entertainment has developed over centuries. All creations come from ideas. For an idea to become an actual piece of work, the process would inevitably involve an ongoing flow of creativity. A piece of work can always be the inspiration of a new idea, which will become another piece of original work. Andy Warhol borrowed the Campbell can designs for his famous work, Campbell Soup. Classical music, Johann Sebastian Bach in the 18th century borrowed or copied from early Italian Baroque masters such as Vivaldi. Joseph Haydn borrowed from Johann Sebastian Bach. Beethoven borrowed from Haydn in his Symphony No. 1. All these composers and artists would be sued for copyright infringement should they be alive today. So the question that we should debate here today in this council with this bill is a chance to amend the copyright framework to promote creativity. Where should our law draw the line in terms of infringement? This line to prevent others from dealing with existing work is the right to protect existing work. Does the bill pending resumption of second reading today draw the line in the right place? I say there is great room for improvement to promote and further creativity, at least when citizens are creating for the sake of creating, not aiming for commercial profit or private gain. Our copyright framework has remained largely in favor of those who have created work since its invention has developed over time to catch up.
Mr. Kwok, please hold. Mr. Albert Chan, call for quorum, please.
郭榮鏗議員。
Mr. Kenneth Kwok, please continue.
Our copyright framework has remained largely in favor of those who have created work since its invention has developed over time to catch up with technological development in the context of protecting copyright owners. For example, apart from having the exclusive right to copy the work, the owner has been given an exclusive right to make available copies of copyrighted work. This was added when wireless transmission was invented, so exclusive right was given to the owner to broadcast their work in the air. Today, again, the bill is in front of us, is trying to catch up with the advancement of technology by copyright owners and exclusive right to communicate the work to the public. This targets new technologies such as online streaming of copyright work. The UK has introduced this exclusive right of communicating the work to the public in 2003, so that infringement does not necessarily involve a copy of the work anymore. Quite obviously and truly, our copyright law is indeed outdated, and the introduction of such a right when the current bill proposal is long overdue. There is also adequate and actual protection for right owners in place, criminalizing those who distribute and communicate pirate copies to the public. So the current bill is rightly catching up with the technological development and does well in the context of protecting the rights of existing copyright owners. How about the other side of the coin? The alleged aim of copyright law to promote and ensure creativity. Everyone can have an idea and everyone should be allowed to create. The right to create should not be an exclusive right which existing copyright owners can monopolize. This is particularly important today, where materials for further creation are so easily available on the Internet. The Internet has democratized the creative culture, turning used-to-be copyright owners like you and me into potential artists. Today, it is so easy for us to appropriate and sample music so that we too can produce remixed music. Today, it is so easy for us to take out clips from movies we like, make a collage and pay tribute to them. Today, it is so easy for us to Photoshop Spider-Man to mock somebody, perhaps a political figure. Today, it is so easy for me to sing my favorite song and then upload it to YouTube to share with the public. Foucault once said that any person interact with an art piece could be an author. The creativity of ordinary citizens should be recognized, and we should all be given a fair chance to create. In fact, in Europe and the US, lawyers and academics have argued that copyright law in fact stifles creativity in this digital era and advocated to the abandonment of the entire copyright regime. President, it is not my submission or my point that we should repeal the entire copyright ordinance today, but it is a valid debate that is ongoing in the rest of the civilized world. This demonstrates that the existing copyright regime, which focuses on the protection of the right owners with existing work, is very outdated indeed. We need a legal framework which promotes and encourages creativity in 21st century Hong Kong. And we have creativity. We should be allowed to create, more importantly, to create freely without the fear of being sued or prosecuted. This is part of our freedom of expression, which is guaranteed under the Basic Law. Sadly, the administration has chosen to adopt a very restrictive framework in driving citizens from creation and innovation. I'm very much aware that the administration has introduced additional fair dealing exceptions into the current bill. Section 39 on criticism, review, quotation and reporting, commenting on current affairs, and Section 39 capital A on parody, satire, caricature and pastiche. That these acts in principle would not be considered as copyright infringement if they are fair, mainly if they are non-commercial, non-derogatory to the original work. I admit that these additional provisions are improvements upon the current legislation, but I'm not satisfied that these amendments are good enough to promote creativity for two major reasons. First, these statutory protections are at risk of being taken away by private contracts. The administration refused to make such protection absolute in the context of civil liability. For example, when I say examples, these are of course hypothetical situation. But if you buy a copy of the Spider-Man DVD, Sony Pictures can put a statement on the DVD box to contract out of the statutory protection for criticism and parody. Facebook can in turn insert into the terms of use so that the users would voluntarily give up their fair dealing protection under the copyright ordinance to quote or comment on copyright work, use the work to comment on current affairs, and use the work for parody, satire, caricature, and prestige. Freedom of contract, as we all know, is not absolute, especially when copyright owners have much greater bargaining power in contracting out of statutory protection than the users of ordinary people like you and me. Therefore, I propose a CSA to introduce a contract override provisions so that all such contractual provisions which attempt to limit the freedom of expression or contract out of our fair dealing provisions would be rendered invalid. Secondly, there is too much grey area in the bill which could deter average citizens to create. Whether all these secondary creation acts that I mentioned earlier would be protected under the bill if it is passed is a question unanswered. Acts of recreation or secondary creation, if they do not fall under the 6 fair dealing exceptions, may be still an infringement under the law, even though I only wish to share my artistic talent with no private gain or profit and do not wish to make any further money from the act of doing so. Why should a person be penalized under the existing legislation? Our law should recognize and give a fair chance to those who wish to create, particularly
With
on the
Honourable
basis...
Dennis Scott, please.
主席，請你點算？
President, I'd like to call for a quorum, please.
黃榮興議員，請你繼續。
Mr. Kwok, please continue.
Thank you, President. Our law should recognize and give a fair chance to those who wish to create for the sake of creativity. I must take this opportunity to reply to what my colleague, Mr. Michael Tan, has said about my criticism of Secretary Greg So. I must emphasize that I expressed disapproval of Secretary Greg So's attitude because he was making a lot of misleading statements regarding the legal position of the bill to the press through the microphone outside this chamber, but refused to put the government's position on the record inside this chamber. For example, the Secretary rebutted my friend Fernando Cheung in saying that streaming and the playing of games online is permitted under the bill, but there is actually legal risk, which he has not mentioned. He's being irresponsible and misleading in trying to persuade members of the public to support this bill, when he should at least have the integrity of putting the government's position on the record in this council. The copyright law must also protect citizens from the risk of political and selective prosecution. Today, we have a bill which is making substantial, albeit inadequate, improvements to the current legislation, but it meets with great opposition from the public. The government is to be blamed for such phenomenon. There is a severe mistrust between the public and the government. In the past few months, we see questionable prosecutions brought by the government, and it is natural and reasonable for netizens or citizens to query the government's motive behind this legislation, especially when the proposed bill is unclear. My colleagues and I have also raised various concerns about the bill being too restrictive in the context of secondary creation, and suggest that the government should further improve this bill at the Bills Committee. The Pan Democrats and myself have proposed several CSAs to remedy the inadequacy of the bill, the contract override provisions, UGC, and fair use. These committee stage amendments will be wide enough to cover all the not-for-profit secondary creation that the citizens or netizens are concerned about. I'll be happy to talk about these CSAs later. Is the bill in front of me a better version of the current legislation? Yes, it is, but it is nowhere close enough to being good to strike a balance between the rights of copyright owners and promoting creativity. Having certain additional but discrete fair dealing exceptions are improvements, but they're not good enough, and they are too conservative for 21st century Hong Kong. Hong Kong, which is aspiring to be the Asian center of creativity and innovation, having just established the Innovation and Technology Bureau, should implement a copyright regime which embraces creativity while protecting the rights of existing copyright holders. As a member of the Bill Committee of this bill, and having participated substantially in the deliberation of the bill, I regret to say that the current bill fails to achieve the purpose of promoting creativity in this digital era. I'm left with no choice but to oppose the resumption of the second reading of the bill to express my dissatisfaction with the current state of affairs. Thank you, President.
Professor Joseph Lee. Mr. President, I have just read a feature article which is very interesting. I want to speak on the topic. In Ming Pao, it said that sit there and do nothing. I recall a comic about MacDowell. When you face danger, you just sit there and don't move. Why are we here sitting there and don't move? It's about copyright. And I looked at some articles. I'm not a member of the Bills Committee. I read an article. Let me share that with you. This morning, different members of the Council have spoken on the copyright law and also the concepts. On the 12th of December, Ming Pao Magafai had an article on copyright. He said that the dispute over copyright is its draconian nature. Now, in the Internet era, this draconian nature cannot be upheld. Therefore, they become more draconian. They rely on the protection of the law. They rely on the power of the financial corporations, the big corporations. They want to maintain their hegemony. But this is mission impossible. unless you have to pay a heavy social cost and distort the free nature of the of cyberspace. Copyright embraces everything. The so-called wisdom you have created or the product you have so created, whether they are songs or lyrics or just a simple drawing after you have registered it, you are not just owning the right of creation, it's also the right of use, right of communication, right of alteration, this right and that right. Anyone touching on that will be regarded as infringing on your rights. In view of this product, we can only passively enjoy it, and that is to pay for that. Whether we sit there and stand there and consume, if you take any initiative such as secondary creation, whether just like the sea, you sing the song and then put it in the internet, then you will have, of course, pay the license fee. You have to obtain the prior approval of the copyright owner. Even if you want to pay him, he may not want you to do it. According to Ma Gafai, this is a kind of a pig. If you touch its hair, you have to pay. If you skin it, you have to pay. If you touch its tail, you have to pay. Everything is about money. Wisdom is money. Knowledge is money. Copyright is built by banknotes, and nobody cares about how big the extension of the right is. His view is that this type of copyright protection is a monopoly. Under the capitalist era, in the pre-internet culture, that might be barely possible. But under the present circumstances, with the change of consumption behavior, consumers cannot do much when couldn't do much when it was in the olden days. But in cyberspace, a lot of new technology can be introduced. Much energy can be introduced. The consumer, instead of a passive consumer, becomes an active consumer. Everybody can easily alter, reorganize, remix the product, and that poses a strong challenge to the copyright concept. That explains why we have to sit here and do nothing to protect the netizens, to make the concept of copyright easier to be accepted. In cyberspace, we move 3 amendments. The first amendment is to give UGC, to establish UGC, user-generated content. The user, in his personal use, can create derivative products, and he can be given exemption if it is not for profit. Mr. President. Now, yes, Professor Lee. Mr. President, a quorum call, please.
李國麟議員，請你繼續發言。
Professor Joseph Lee, please continue. Thank you, Mr. President. Just now, because of the nature of copyright, which is so imperious, members therefore want to move certain CSAs, and I've just spoken on UGC. Let me speak on this once again. It is hope that users in creating secondary creative products, if they do it not for purpose of profit, they can be given exemption. To meet such exemption, one has to fulfill certain requirements. It has to be personal use, not for profit. And the one who does the creative work will not infringe on the right. Reference is only making reference to the product, and there will be no substitution nor replacement of the original product. That's the first amendment we want to move. The second will also try to set the hearts of the citizens at ease. Then that is introduction fair use. At present, the copyright ordinance has been adopting the concept of, or has adopted the concept of fair dealing. Secondary creation, which is not in the exemption area without the permission, that is of the copyright owner, that will be in breach of the law. But fair dealing is different from fair use, and we want to introduce the concept of fair use. If fair use is introduced, then people will have better protection. Whether it's secondary creation, whether as far as secondary creation is concerned, whether it's pastiche or not, or parody or not, as long as it's fair use, it will not be in breach of the law. And the third amendment we want to introduce is contract override. Just now, Mr. Dennis Kwok have spoken on that. By introducing contract override, it can protect the netizens. One may not know whether the copyright holder has put in a contract term which doesn't allow secondary creation. But since there is contract override, then the author of secondary creation will be exempted. This can balance the draconian nature of copyright. Now, everybody is sitting here and doing nothing because of the following. Well, there are many people giving different interpretations, but McAfee has also written an article, and that is because of the absurd behavior of the administration. The administration just said that I'm not going to make any change. It has already gone through the Bills Committee. It has got the approved support of the Bills Committee, and the government is not going to move any amendments. The administration claims that it has done a lot of things in the past 10 years. It has done a lot of consultations. It's impossible to wait for the changes made by advanced countries. McAfee's article has pointed out the absurdity of this position. It is entirely the making of the administration. Why copyright is so outdated in Hong Kong? Because the administration has not done enough, has not done it fast enough. They have adopted different useless approaches. They said it's consultation. They put it up for consultation, and then they withdrew it. And then they made proposals. There were many disputes. I know that they have their war room, and what I said is put on the media, and they refute my arguments. The officials dealing with intellectual property is incapable and bureaucratic, and therefore the copyright law has been outdated. It is obvious that the amendment bill before us has many flaws. Why can't new measures new provisions be incorporated? Say, for example, the contract override, which is being used in the UK, and also the administration refuses to give the undertaking that access to computer with dishonest or criminal intent will not be invoked to implement the copyright law. Now, in fact, the administration is lazy. They just hand in their homework and then then that's their intention. It seems that it is filibustering. But the problem is why the administration rams it through. Why can't the administration amend the bill? The administration ignores public opinion. The administration ignores the shortcomings of the bill. The administration just has an antagonistic attitude. Now, say the netizens ask the administration to choose between UGC and fair use. But the copyright owners just say that all or none. Now the administration puts us on the spot and accuses us of filibustering. But has the administration considered the nature of this bill? After the conclusion of the Bills Committee meeting, there are still many criticisms. Under such circumstances, shouldn't the administration further discuss the matter before resuming the second reading? Just said by the CSOA in March, we may have a chance to discuss the budget, and we are still considering the copyright amendment bill, and the CSOA says that the appropriation bill arising from the budget should first be considered. The administration has done nothing and tries to ram the bill through. It is your own making. You are antagonistic. If you say A, then I say B. If you say it's right, I say it is wrong. It seems that we only have a few months ago. Should everything be jammed? The withdrawal or passage of the bill is the issue. If that is the case, then we should set up a select committee and look into that. That's also another way to climb down. It's better than doing nothing and sitting here. Is it really helpful? Can this help? Basing on this, shouldn't the administration go back and look into that, withdraw the bill? After it has been taken away, then we can discuss other bills so that we can benefit the public. Because of this, I am against second reading of the bill.
President, please call for quorum.
有冇議員要？
Does any other member wish to speak? Mr. Ray Chan? Thank you, President. President, in the second reading debate, I would oppose the 2014 Copyright Amendment Bill. I'm a member of the Bills Committee, and I have spent a lot of energy to follow up on the bill. I'd like to say to you here that this might be one of the fiercest wars at LegCo here. The 26 members of the pan-democratic camp are joining efforts to block the passage of the bill. But I'd like to tell you that we are not saying that a new bill on copyright must not be passed. That is why at the Bills Committee I proposed amendments with regard to fair use and open exemption. Other members are moving amendments too. Mr. President, you have accepted 42 amendments to be proposed by Mr. Wong Yuk-man. Many of them have substance. They serve to perfect the bill. What is unfortunate is the tradition of our bill's scrutiny work is such that if the amendments are supported by the administration will take on them and will move the CSAs, and that is all so much better because there is no need for split voting. However, if the administration doesn't support those, even if the CSAs proposed by us are valuable, the administration would order that none of them be passed. But this time around, I hope the administration would really listen to the views and worries of members and the community. There is a report in the newspaper saying that Mrs. Carrie Lam considered taking out the bill to allow other bills to be passed first, but then she said she did not say it. Now, I'm not going to argue with her. It seems we are staunch opposers of one another, but is that there's such a big distance between us. In fact, I have a lot of consensus with you. Number one, there is no perfect copyright law. Copyright law is about balancing of interests. Theoretically, the administration doesn't need to have a very strong stance as long as it can balance the interests of different parties. And at this stage, if a law is acceptable to all, then it is a good law. Secondly, copyright protection is important. I think that is consensus. Even netizens, users, they themselves would create works and they may become copyright owners one day. And without copyright protection, without investment, without returns, there will be no products or works. Number three, whether we should combat piracy. Again, there is no discrepancy here. Everybody wants to combat piracy. If there is large-scale piracy and also piracy on the internet, that has to be combated. Number four, is there an urgent need for Hong Kong to revise its copyright law? I agree that our copyright law is outdated. But if you are trying to do it so urgently, to say that our present law belongs to the medieval times, to say that it is a dangerous piece of legislation, but then you have to think about what the copyright owners are saying. They say they would rather not have the new bill if any one of the amendments to be proposed by the Pan Democrats will be passed. Let us look at the differences between this amendment bill and the existing ordinance. Whether we pass or veto the law, we would just ask very simple questions. And that is, if the bill is passed, will things be better or worse? When we ask this question, we have to ask, of course, whether it will be better to someone and worse for another. There are many people who are affected by the copyright law. For example, copyright owners. Copyright owners are in two types. One, the authors or writers, and then two, the investors who buy copyright to make a profit. Two, users. Users are netizens or people involving in secondary creation or derivative works. Maybe they do not exactly create, but they use their works to express their feelings and views. Number three, this is a little complicated. We are talking about intermediaries. Who are these people? They are the internet service providers. They provide the connection. They have discussion platforms or even websites that are shared.
Now, for this copyright amendment bill, now people criticize that it is, the existing ordinance is not keeping up with the times because it doesn't have the idea of communication right. In the past, for copyright infringement to take place, you need to make physical copies of the original work, namely audio or video recordings, and then you upload the files online for others to download, and only by doing so can copyright infringement take place. But now, online streaming is a new mode of transmission, and no downloading is required. As long as one disseminates the works through this mode of transmission and somebody receives the works disseminated, then it will be regarded as a copyright infringement. And the bill seeks to plug this loophole. This is technically neutral. It doesn't just tackle online streaming, because with this idea of communication right, any future mode of transmission will be caught. And for copyright owners' representatives, they suggest that if the bill is not passed, Hong Kong will become a paradise of copyright piracy. Any films, musical recordings, etc., will be subject to copyright infringement. And we are on the brink of a breakdown. It's the tipping point. Now, what about the objective of the bill? According to the government and copyright owners, the objective of the bill is to combat large-scale and syndicate copyright infringement on websites. And one prominent example is set-top boxes. And I actually had meetings with the management of TVB and major copyright owners. Now, copyright owners said that they are not targeting ordinary members of the public
who share copyrighted materials online or express their comments. But if the bill is passed, it will go beyond achieving the claimed objective. And there is also the distinction between criminal and civil liability. For criminal liability, the ultimate penalty is to go to jail. For civil liability, to become a bankrupt. Now, for criminal liability, apart from imprisonment, fine is also another possible penalty. Now, for this copyright bill, I think that in terms of criminal liability, the liability is clearer. That is a distribution or communication of copyrighted materials causing economic prejudice. Now, in 2011, there wasn't an exemption, and Mr. Greg So said that now we have more exceptions, but that is not true. Back then, Mr. Ronnie Tong already suggested an amendment in relation to more than trivial economic prejudice, and therefore it wasn't accepted. In 2014, therefore, now we have the new concept. And that is whether it is a substitution, as set out in section 118 2AA. Mr. President, quorum call.
陳志全議員。
Mr. Chen Chi-chun, please continue. Thank you, Mr. President. I was talking about criminal liability for copyright infringement. The original objective of the bill is to combat large-scale copyright piracy. However, for 1181B of the bill, it says for copyright infringement on a personal scale, although the infringers may not have an apparent profit motive, if there is economic prejudice caused, then it can still be regarded as copyright infringement. I agree that it may cause more than trivial economic prejudice to the copyright owners. For example, if I upload a song or if I download movies instead of buying a DVD, then they will not be buying from the copyright owners. But can we resolve this by claiming civil liability other than criminal liability? The Big Crook case happened in 2005, and he uploaded the 3 movies to the internet for downloading by others, and he was imprisoned for 3 months, sentenced to 3 months in imprisonment. The maximum penalty is actually under the existing ordinance $500,000 in imprisonment. Now, a balance should be struck between the interests of different parties. And can a balance be struck now? The concept of communication right will be able to catch all future modes of transmission. And at the same time, therefore, exceptions should be given to netizens and users so that we can decide whether a balance can be struck, whether it is fair and palatable. And after including exceptions in the bill, we need to consider whether it will offer greater protection, whether there will be a lesser or greater chance for netizens to be sued by copyright owners. The government says that there is a greater extent of protection because of the 6 new exceptions. I won't repeat. Let me give you an analogy. In the past, we could we could fly anywhere. We could go to Hong Kong, Kowloon, the new territories, and yet now the government suggests that this is no longer the case. You will be shot down if you if you fly just anywhere, and yet we're going to give you some exceptions. I can give you a wide scope exception as wide as the Victoria Park, so that you will get some protection. Netizens said that they used to enjoy freedom in reigning the territory, but the government suggested that in fact copyright owners under the existing ordinance can still claim liability. And netizens then ask why copyright owners have not relied on the existing ordinance to take legal action. And now they are pretending to be merciful. But in fact, the fact is, even if you want to shoot down the plane in the sky before, that you may not be able to aim correctly, and you may not be able to recover the loss. So we need to ask, first of all, whether the exceptions will offer greater protection or not. Mr. President, a call for quorum, please.
陳志全議
Mr. Chan Chi-chun, please continue. Mr. Greg So said that there will be 6 new areas of exceptions under the new bill. Originally, under the existing ordinance, there are already 60 exception provisions. So we should pocket it first. Well, no, Secretary did not say pocket it first. In his speech in the adjournment debate, he said that we should cash out to make a profit first. Well, that really exposed what Secretary thinks. He is thinking from the perspective of copyright owners, not from the public. Why are we wary about passing the bill with 6 new areas of exceptions? Because it will be dangerous for us. We can be shot. Because copyright owners would say that these netizens should be sued because they're on the borderline cases, and therefore I've proposed the open-ended fair use approach to give greater protection. You need to put the two on a balance to decide whether it is in all fairness to sue the netizens. And if we can't decide that, the matter should be taken to court. And in fact, even Mr. Tam Wai Chi, the chairman of the Bar Association, also made the wrong comparison. Well, what's good about that, my amendment, is that I have kept everything. I have not deleted anything. The 6 areas of exception will continue to exist, but there will be a safety net in the form of a fair use doctrine. That is, there will be a criterion for fairness assessment. We don't need to go back to the Legislative Council and put up a struggle for years to decide whether the 7th exception should be granted. I so submit.
Mr. Yip Kin Yuen.